calendar. It is Leal versus Adamson, 24-4594.
Hi, my name is Chris Davis, and I'm here for the appellant. I would like to attempt to reserve 2 minutes for rebuttal. I'd like to thank the panel for the opportunity to present my arguments. Sorry. To the extent Leal alleges any state law claims, both this court and the district court lack jurisdiction over these claims. Nevada has not waived its sovereign immunity protected by the 11th Amendment, and Nevada law, Leal cannot invoke the waiver of sovereign immunity and present his state law claims against the defendants without naming the state of Nevada, which he cannot do. The district court erred when denying defendants' motion to
Did you waive those claims, or are they not waivable because they're jurisdictional?
Well, only the legislature can waive sovereign immunity.
I mean, in arguing in the district court below.
No, you can't. You don't, because we asserted it as an affirmative defense in the complaint, and therefore it's not waivable. Again,
are those properly before us? Because all this before us, right, is that you can only interlocutorily appeal the denial of QI, qualified immunity. So are those claims properly before us, the state law claims?
The state law claims, yes, because the Supreme Court has expressly said that 11th Amendment immunity is such importance, even greater importance than qualified immunity, that you're entitled to an immediate appeal. In fact, the district court in the Edelman case specifically said that.
All right, well, what about the qualified immunity? Because I thought that was the focus of the appeal.
Yeah, that's what I was getting to, Your Honor. He's not plausible alleged fact showing an Eighth Amendment violation, let alone alleged
So
facts
I'm having
saying,
a really hard time understanding you.
Oh, sorry.
Can you slow down just a little bit?
I will try, Your Honor.
That's okay.
I apologize.
That's all right. Go ahead.
Much less violate a clearly established constitutional right, which is required to overcome qualified immunity. Defendants did not violate the Eighth Amendment when treating Leal's back, because Leal has merely alleged a difference of opinion between one NDOC doctor and the doctors on the NDOC Utilization Review Panel, or URP, which, as a matter of law, cannot establish an Eighth Amendment violation. Leal admits that the medical providers ordered multiple x-rays, which revealed no injury to his back, and that Leal was provided with pain medication to treat the injury to his back. As set forth by the Supreme Court in Estelle, the decision to provide additional diagnostic tests or other forms of treatment other than pain medication is a classic example of a matter left to the doctor's medical judgment, which includes the judgment of the URP panel.
So we're at 12b-6,
Right.
and we're just talking about whether or not he received adequate care and what his allegations are. So we're not going into any fact finding. He alleges that this was not the appropriate treatment, because he just got ibuprofen and it wasn't working and they just continued. That's his argument.
And that was the same.
We're just looking at his allegations. Okay.
Yeah, and that's the same argument that was made in Estelle. Estelle was the motion to dismiss claim too. And Estelle, I'm sure they made the same arguments, and they said, hey, we're just on a motion to dismiss stage, we're here, but the Supreme Court still says, this is a matter left for medical judgment. What he would need to do in order to, in alleging his complaints, he would have to follow the constraints of Edmo. Edmo provided a small exception to this claim. In Edmo, the district court affirmed the decision that differences of medical opinion, it says that's generally what's held. You have a difference of medical opinion, no Eighth Amendment violation. But in Edmo, they made a small exception, which said where if you have a highly qualified expert that says that it is, that opines that he did not follow the accepted standard of care and it was medically necessary. In other words, the standard in Togliatti. Here, Leal does not allege anything similar to that. He doesn't allege that he has, that any medical provider ever alleged.
Wait. This just isn't right. What he alleges is it's not about the failure to give the MRI. He certainly takes issue with that. And I take your point about a difference of opinion about at what point an MRI was called for. What he alleges, which we don't know, we're not going to make a finding about this, he alleges that the appropriate course of treatment would have been physical therapy, epidural injections, and surgery, and that he did not receive that care.
Right.
And there was a very, in this case, a very significant delay, and that caused further injury. We don't know if any of that's right. We're just at 12b6. Right. You really seem to be making summary judgment arguments, sir.
No, Your Honor, I'm not. If you review our briefs, we are relying entirely on the allegations in his complaint.
Okay, so let me do it this way. I created a timeline because for both of you, I think this would be helpful. I created a timeline because he saw so many different care providers. And it seems to me that there is a question about one of the allegations he takes issue with is that he wasn't given an MRI, right? And the Medical Review Board looked at that twice. And the first time they looked at it in June of 2019, which was less than a year after the injury, and they said no MRI, right? But again, it hadn't been all that long. And then in April of 2021, when they looked at it, they allowed the referral to the expert, right? There's another physician by the name of Dr. Pena and Dr. Sanchez. Dr. Sanchez in particular, who saw him just one time. So if you're talking about deliberate indifference, it seems to me, and this person just saw him one time and only in October of 2018, which is very close to the time of the accident, it seems to me like that allegation is going to fall short as to Dr. Sanchez. But as to the other care providers, there are a couple that saw him multiple times for many, many months and really just kept prescribing ibuprofen. And that wasn't alleviating his pain, apparently. So why doesn't he have at least a colorable claim as to those care providers, sir?
Because as you said, if you review the timeline that they provide, Your Honor, what you see is progressive care, progressive increasing more care provided.
No, we don't. We don't see that.
Oh, okay.
We see that what he alleges, and again we're at 12b6, is that he kept just getting ibuprofen.
No, Your Honor. He also alleges that he was provided X-rays. He was alleges
That's
he was
not
provided.
Care. That's a diagnostic tool. An X-ray is not care. It's a diagnostic tool. And what he said is it wasn't working. Nothing was alleviating his pain. You started. Let me do it this way. You started it by saying that you don't think that he had a significant medical condition, right?
He doesn't have objective evidence of some medical condition.
Okay, we're not talking about objective evidence. We're talking about his allegations at the 12b6 level, and he's alleged that a condition that significantly affects his daily activities, or evidence of chronic and substantial pain. Would you agree he's alleged that?
Yes, he has. He's alleged, but the evidence of this court has ruled that claims of pain is a subjective phenomena. In other words, what you have to have is you have to have objective evidence.
Right, and so what he's alleging is that he couldn't sleep, he couldn't stand, it affected his mobility and his ability to sit or to sleep or to stand, I believe.
Right.
We're just at the allegation stage, so it seems to me he's clearly alleged what it takes to get over the hurdle under our case law.
Well, Your Honor, I would respectfully disagree because the cases that we cited in our brief all say that you have to have objective medical evidence of those phenomena.
Not at the 12b6 level. So look at I think what you're really arguing is deliberate indifference, and that's where I think the timeline comes in. Because, for example, for Dr. Sanchez, he saw this person one time and only very shortly after the accident. That's qualitatively different.
Well, Your Honor, but I would submit to you, Your Honor, what it's showing is at each level that the care gets progressively better. I mean, not progressively better, but progressively more aggressive in treating him. He gets X-rays, right? And I respectfully disagree, Your Honor. Well, an X-ray is a diagnostic tool. They use the diagnostic tool in order to determine what treatment to provide. And the X-rays consistently show that there is no injury to his back.
What discovery has been conducted so far? I know there was sort of a beginning of this, and then it got maybe stopped.
Yeah, yes, Your Honor. Because what in the factual timeline of this, when this originally came out, that they had that he was not represented by counsel. They do a couple of amendments to the case. Counsel comes in. They do a second amended complaint. The complaint is no longer liberally construed.
Right, but so what discovery, if any, has been conducted?
I understand there's been some document production. I think there was a deposition. I don't know if there was a deposition. I wasn't counsel at the time, so I'm not sure that there was a deposition conducted. There was a deposition, at least there were depositions scheduled, but I'm not sure if they went through, Your Honor. Just don't.
Would you like to reserve any time?
Yes, 2 minutes if possible. I guess I got 30 seconds.
I'll give you 2 minutes when you come back up, counsel.
Good morning. May it please the Court. I'm Ryan Norwood representing Mr. Leal. If I could start by answering your last question, there was actually a lot of discovery that was conducted in this case before it was stayed for this appeal. There were documents provided by both sides. There were 2 depositions done of defendants, Landsman and Augustin, and they were experts.
Which Augustin and who was the first?
Dr. Landsman.
Landsman, okay.
And there were actually experts noticed by both sides. We provided a report. It's in the record because I put it there when we were arguing over the stay, where our doctor had reviewed the records and determined that the course of treatment was medically unacceptable under the circumstances. And
so what other discovery do you think would need to be taken if the case is allowed to proceed?
When the case was stayed, what we had pending was a notice deposition of their rebuttal expert and some interrogatories that were before the individual members of the URC, in part to determine how they actually voted. There was also, I believe, there was another notice deposition regarding another.
Have you received records from the URC? Do you already have all those documents?
We got discovery again that included the names of the URC members, but not a record of how they actually voted.
Or the materials they reviewed in making that vote, things like that, you
Correct.
think you still need?
Correct. No, we still don't have that. I mean, it's still not a complete record. We made some significant progress towards completing it, but there are still a few things that need to be done. Quite frankly, I think it would have been easier if we had just completed that discovery rather than come up here for this interlocutory appeal.
I mean, one of the things about this case, it's there's a lot of people, and then it progresses along a timeline. And presumably your argument is as things went on, it got worse and worse because the more time that went by, the more deliberate and different people were. I mean, this is kind of the nature of a case like this. Early on in the case, you have some doctors that are looking at him, but they only see him briefly, like Dr. Pena. Dr. Sanchez, I believe, is one. Dr. Pena, maybe. So why is there a deliberate indifference claim as to them?
I believe our allegations are somewhat broader than that. It's true that in the complaint we refer specifically to one visit by Dr. Sanchez and one visit by Dr. Pena, but it is specifically alleged that they were responsible for Mr. Leal's care during this early period. And we're talking about a period of months here.
Forgive me for interrupting, but do you think you have a complete record of all the times Dr. Sanchez saw your client?
I'm not sure that we do, and that's, again, another thing that we might want to fully develop in discovery here. We are alleging what we knew at the point that we submitted the complaint about these 2 specific visits, but we are more broadly alleging that they were responsible for their care. So I'm not agreeing at this point that that's the only time that they were in a position to provide medical care for Mr. Leal. Another point I want to make about these progressive providers is that there's a record that's available to them. And we specifically allege this, that there's a record of complaints made by Mr. Leal that would have been available to the subsequent providers. So
That's why I'm a little confused about your response to Judge Bress's question, is that considerable discovery has been done. And I guess I'm envisioning, a patient file where you'd be able to see which physician saw him when and how many times? Is that maintained electronically?
Most of their files are not. They're on paper, and I receive copies of them in a PDF form. Frankly, they are very hard to read. A lot of it's handwritten. So even when I get the record, it's not always clear exactly who was doing what when. That's in part why we sought depositions of some of the providers to clarify and to, frankly, interpret some of the stuff that's in the record here, because you can't read a lot of it. Just a couple of other issues that came up that I'd like to address in my time. Defendants brought up the state law claims. There were state law claims pled. They were not the subject of the motion to dismiss. I mentioned in
front of us, right?
No, they're certainly not. I would argue that they've been that the motion to dismiss has been waived at this point.
But I take yes for an answer on that one. They're not in front of us.
Yes.
Okay. Is there another matter you wanted to raise?
Just briefly, the Estelle case was mentioned. I wanted to point out that that's a very different factual circumstance involved there. Estelle noted that in that case, the plaintiff had acknowledged that he received extensive medical care, and that what he was alleging there did amount to just a difference in a disagreement about treatment. That's not what's alleged here. This court has never interpreted Estelle to mean that just because you get some care, there's no deliberate indifference because it falls into a disagreement pattern. So the case.
I think that does get into kind of the crux of the case a little bit, which is that we're here on 12b-6, so it's a favorable standard to you. On the other hand, the deliberate indifference standard is a hard one, and in a lot of these cases, just in candor, you see maybe more deliberate indifference than what's alleged here, because he has a consistent pattern of treatment. There's an allegation that the treatment wasn't working. But at the end of the timeline, we find out he has an MRI that reveals a congenital defect, and it's not apparent from the face of the complaint, exactly what more one is claiming could have reasonably been done. And when you have a series of kind of ongoing review and ongoing doctors, it just may create some impediments to actually proving up this claim under the legal standards.
I mean, I will agree with you that deliberate indifference is not supposed to be an easy standard to meet, but that it just comes back to this is not the proper stage of the proceedings to be trying to resolve these questions.
But you agree you're going to have to show your client's going to. It is a tall order. You'll have to prove, right, that there was actual an exacerbation of the injury because of the delay. The delay alone is not going to be enough, right? I think that's pretty well established. And you've alleged it. The complaint alleges it. I'll give you that. And my understanding, and this is kind of important given opposing counsel's comments, it's important to me anyway, that this is not a claim that is dependent upon difference of opinion about whether or when an MRI was warranted. The allegation, or at least it's not limited to that, the allegation in the complaint is that for this very, very persistent back pain that became symptomatic after this particular injury, that there was a different course of treatment that would have been called for, so that's going to require expert testimony. We don't have that yet, but that's why I'm seeing the trajectory of this case going. Do we have a difference of opinion on that?
I agree with you that if at the end of the day we're only able to show that there's a reasonable difference of opinion, then that's not going to meet the standard. But what we're alleging here is that the failure to give the MRI was medically unacceptable under the circumstances.
Because it became, as Judge Bress said, because this went on and on and on.
Well, it's one of the reasons, yes.
Right, well, that's why I think he and I both are calling your attention to Dr. Sanchez, who, from what we can tell, only saw the plaintiff one time and within the first month after the injury. Maybe 2 months or 6 weeks or so after the injury. So that's really tough to show deliberate indifference.
I would agree if we're ranking people, as far as, say, Dr. Augustin, who saw Mr. Leal numerous times over the course of the year before he finally referred him to the orthopedist, that there might be a difference there. But that doesn't mean that it couldn't meet, that it's not implausible that it could meet the deliberate indifference standard. I would respect.
I think it is implausible if you only saw him the one time. Hence my question. I think we both asked the question.
Was he seen Pena.
Again?
Yeah, the same with Pena. I mean, we just wouldn't want to keep people in a case if there's not a fair allegation against them. And some of these doctors, there's very limited mention of them in the complaint.
I mean, with Dr. Pena, again, he would have the benefit of Dr. Sanchez, who I believe was the first. Maybe I have the order mixed up, but
Dr. Payne, you saw him first. You saw him on September 4th, so right after the injury.
Right. So
And he's the one who ordered an X-ray of the foot. Because apparently there were other potential injuries there, but not an X-ray of the back. And then Dr. Sanchez saw him on October 10.
I understand what you're saying, and I understand the concern, but my respectful view is that they should stay in the case at this point under the 12b6 standard, and if we're ultimately unable to show after discovery is completed that there was deliberate indifference, that would be the proper time to remove them.
Okay, thank you.
If I may, have those doctors been deposed?
No, they haven't.
Is it your intention to do that?
I might do so, yes. Yes, I think if we would want to keep them in the case, it would be important to get more information.
Okay, can I ask you one last question? So how about the warden? I mean, the warden is not a doctor, so what is the basis for the warden being deliberately indifferent?
There are some very specific allegations by Mr. Leal that he specifically notified the warden of the ongoing situation in person once and in writing on another time. There is case law holding that a warden can be responsible under some circumstances for knowledge, given the specific allegations that we have here.
So, just personal curiosity, I guess. Why is the federal public defender doing a 1983 action? Is that normal? Or?
No, it's not normal. We represented Mr. Leal in another action. The court ruled that this proceeding was ancillary to it and appointed us.
It was a habeas action? You guys represented him in another habeas action, and this is in 1983 is ancillary to the. So that was the district court appointed you for this?
Yes.
How often do you do 1983 actions?
Not very often.
Okay. Interesting. All right.
Thank you for your patience with our questions. We'll give opposing counsel 2 minutes.
Thank you, Your Honors. There's been some discussion about the difference between summary judgment standard and the motion to dismiss standard. And I think that the court should remember that the principal difference between summary judgment and a motion to dismiss is at summary judgment there has to be evidence. At the motion to dismiss standard, there only has to be allegations. There doesn't have to be evidence. But there still has to be allegations.
Look, counsel, this is an extraordinary record that we have here. In the district court, there was a motion filed by the state. It's page 11 in particular, where there was a citation in the state's brief to an online article that from the Cleveland Health Clinic. And it was cited, page 11, the state argued congenital narrowing of the spinal column is genetic, meaning it is not part of the normal biological process and was not caused by the defendants.
Right, and we asked.
It's entirely extraordinary that the state would be making that argument in response to a 12b6 and trying to, and then argue later that we should take judicial notice of the article, sir. So
Well,
I'm a little aghast that you're reminding us of the standard between 12b6 and summary judgment, which we're very mindful of.
Well, Your Honor, I'm just trying to counter the argument because it's not alleged in the complaint either that they were trying to make the argument. They were trying to speculate what the congenital narrowing of the thing of the.
But we don't know. And we certainly don't.
Right, and that's kind of the point I was making there.
We just know that he's alleged. We just know that he's alleged that he had an injury, and then this became symptomatic. That's all we've got.
And then the other thing I would like to remind the court of is that, well, correct a misstatement, that Estelle it was not about extensive health care. The only thing they did at Estelle is they gave pain medication. They didn't order x-rays. They didn't do anything else. That's the only allegations in Estelle. So I think Estelle is full on board. And the other thing I'd like to remind the court is that these are individual defendants. You can't collectively sue them and say, hey, this doctor, over the course of the year, we're looking at this, and so if we look at all of the care he got, then we're going to say it's deliberate indifference. But what you have to do is what the individual doctors did. And you have people like a doctor who ordered the X-ray and MRI, and they're suing him. I think the courts pointed out that the warden is not a doctor. The medical records, if he even could understand and review them, they would have come up and said, hey, the panel has already made a decision. I can't override the panel's decision. You got early doctors who couldn't possibly have anything. And finally, you have Dr. Augustin, who orders orthopedic surgeon, who they admit.
So you're well over time. I'm going to ask you to stop there. Thank you both for your arguments. We'll take that matter under advisement.